some breaking news that we are getting on the broadcast, and this concerns the Gyanvapi verdict. Now, we've been told that the Allahabad High Court has refused to interfere with the Varanasi Court's September 12th, 2022 order that dismissed the Gyanvapi Masjid Committee's plea challenging the maintainability of the suit filed by 5 Hindu women worshippers. So this is another victory for the Hindu side as far as the Gyanvapi case is concerned. Remember, there was a maintainability plea that was put before the court by the Muslim side, by the Gyanvapi Masjid Committee, where they had questioned the maintainability of the Hindu side's plea, and now the Allahabad High Court has refused to interfere in what has already been decided by the Varanasi Court on September. Let me bring in my legal correspondent. Ananya is joining us on the broadcast with all of those details. Ananya, what were the clear grounds that the Allahabad High Court decided not to go ahead and interfere in the Varanasi Court's verdict, considering there was a maintainability plea that they were looking at? What really transpired in the court where they said that they are not going to do anything about it?
Well, Greha, the detailed order copy is not out yet, but what we know at this point of time is that the Allahabad High Court dismissed the Order 7 Rule 11 application that was filed by the Muslim side, challenging that particular order of, the Varanasi District Court, clearly saying which had basically allowed the application by the Hindu side to actually worship in that particular, seeking permission to worship in the Adi Visheshwar temple there in Varanasi. But at the same point of time, the Muslim side challenging that particular order, filing up Order 7 Rule 11 application, which basically means that, under Order 7 Rule 11, civil suit can be dismissed if the court does not find a cause of action that is available in law, which basically means that, if at all the court finds that the relief that are being sought in a particular petition or a particular civil suit cannot be granted as per and under the garments of law, then the suit is dismissed. But definitely the court has found some kind of, straight facts with what, in fact, the Hindu side has been claiming in its arguments. And the arguments have definitely succeeded that the Muslim side's Order 7 Rule 11 application has now been dismissed by, in fact, the Allahabad High Court as well. Now, the next step would be for the Muslim side to actually approach the topmost court of the country, that is the Supreme Court of India, in order to challenge this particular order of the Allahabad High Court as well. But whether or not Supreme Court would interfere, because already there are two court orders, and definitely this would be a reasoned order when it would come out, in fact, in a while when we'll get to see the order copy, we'll be more able to give more details to our viewers to what were the particular grounds or particular arguments of the Hindu side that have been accepted by the court, and why did the court actually believe that there are certain kind of a cause of action that can be allowed in this particular suit. And definitely this is a big win for the Hindu side.
Ananya, I would come back to you. I'm really sorry to interrupt you there. We are getting some legal voices that are coming out after the court had pronounced this verdict. Let's listen in.
पूरा विवरण है, तो वो ऐतिहासिक तथ्य भी है और वर्तमान भी तथ्य है, तो ये सब कुछ हिंदुओं का है। वाराणसी जिला कोर्ट में सुनवाई होगी, आप लोग वहाँ पैरवी करेंगे? हाँ, वहाँ पैरवी करेंगे, वहाँ एविडेंस की लेन देन होगी। हालांकि ऑनरेबल हाई कोर्ट ने तो पूरा ट्राइबिलिटी पे ही सुन लिया था, 20 दिन सुनवाई हुई। ऑर्डर 7 रूल 11 में इतना नहीं होता है, लेकिन ऑनरेबल हाई कोर्ट का ये था कि सबको मौका दें और तमाम एविडेंस लें और उस पर जजमेंट करें, ताकि लोअर कोर्ट को जो है एक क्लियर कट, लोअर कोर्ट को एक गाइडलाइन मिले, मतलब सबऑर्डिनेट कोर्ट जो डिस्ट्रिक्ट जज की है, उनको एक गाइडलाइन मिले, ताकि जजमेंट मिलेगा तो जजमेंट निश्चित तौर पर उनको आसानी होगी।
निश्चित तौर पर ये सौरभ तिवारी जी थे, जो कि रिस्पोंडेंट नंबर 1 राखी सिंह के वकील थे, और इनका कहना है कि इलाहाबाद हाई कोर्ट ने साफ तौर पर मुस्लिम पक्ष की जो आपत्ति थी उसको खारिज कर दी है। जिला कोर्ट
इंतजामिया मुस्लिम पक्ष के उस अपील को खारिज कर दिया कि जो है आप ये जो पोषणी नहीं है, इसको जो उन्होंने खारिज कर दिया, डिसमिस कर दिया। अब इनके पास रास्ता सुप्रीम कोर्ट का ही बचा है। सुप्रीम ये डबल बेंच में जाए, सुप्रीम कोर्ट जाए, इनके लिए रास्ता न्यायालय का खुला है। हायर जो जुडिशरी है वहाँ खुला हुआ है, कहीं जा सकते हैं, ये स्वतंत्र है, इनके लिए आगे जाने के रास्ता खुले हुए हैं।
Let me bring in Mr. Harishankar Jain, the lawyer of the Hindu women's side, who have won this plea once again in the Allahabad High Court. Mr. Jain, could you actually take our viewers through the arguments that were heard in the Allahabad High Court now that the Allahabad High Court has decided not to interfere with the verdict that had come out of the Varanasi Court?
Today is a historical day in Manni High Court, passed by the district judge, by which the application filed by Muslim side that rejected. Now the case will proceed and it will lead to this logical conclusion, and we are hopeful that one day we will be able to remove this structure, so-called mosque, and we will construct a glorious temple as was since before, like Ajodhya.
Mr. Jain, so does that mean that the women worshippers can go inside the mosque complex and pray, which was initially the argument that was placed by your side?
It is what you are saying, that is final verdict. Now, here the question why the case cannot proceed. It is barred by certain act. That bar has been removed. Now case will proceed. And we are sure that we will win. We'll reduce our evidence and then the case will be decided.
All right, Mr. Jain. Okay. Yes. Mr. Jain, once the Anjuman Intizamiya Committee decides to move the Supreme Court in the matter, are you prepared for that?
Welcome. I also want that they should come Supreme Court and we will fight there.
Okay.
We are ready for it.
All right.
We are ready.
Thank you so much for that, Mr. Jain, for joining us on the broadcast. More reactions coming in. Let's take a look.
अंजुमन इंतजामिया की पिटीशन डिसमिस की.
Now, remember, the Allahabad High Court has dismissed the revision plea that was moved by the Anjuman Intizamiya Mosque Committee that manages the Gyanvapi Mosque in Varanasi, and it had challenged the Varanasi Court order of September 12, 2022, dismissing its order plea that was filed last year. And they have, remember, objected to the maintainability of the Hindu worshippers' suit. That has been dismissed by the Allahabad High Court. Let me bring in Anusha, my colleague who's joining us from the CNN News 18 newsroom. Anusha, what does it mean essentially? Even as the Anjuman Intizamiya Committee is now deciding to move the apex court of the country, this is a big win, something that's been reiterated for the Hindu side.
To put it into context for our viewers, this is an initial victory for the Hindu side. What does this order of the Allahabad High Court really mean as far as the Hindu side is concerned? Order 7, Rule 11. The argument of the...
ने भी ऑनरेबल मिस्टर जस्टिस जे मुनीर ने कही है, जिसमें उन्होंने होल्ड किया कि रिवीजन पिटीशन मेंटेनेबल नहीं है और अंजुमन इंतजामिया की पिटीशन डिसमिस की.
Okay, Anusha, I'm really sorry I had to cut across some more reactions. Please go ahead.
So the argument, Reha, that I was making was that earlier the argument at the lower civil court was that whether the petition of the Hindu side is maintainable or not, and there is already a 1991 act that bars any kind of alteration of the places of worship, the Places of Worship Act, which is talked about. Now the lower court had ruled that the Hindu side can actually go ahead and demand their right to worship of Ma Shringar Gauri, and 5 Hindu women had moved to court. Against that decision of the lower court, where it was allowed that yes, the trial can go ahead, the Muslim side went to the High Court and said, look, forget the merits of the case, prima facie on technical grounds, this plea is not maintainable at all. The High Court has rejected that claim. What does that mean? It means that the trial, the civil suit at the lower court can now continue to go on. The 5 women worshippers who had moved the lower court earlier and sought their right to pray and worship of Ma Shringar Gauri can now assert before the civil judge and say, look, this is our right and we must go ahead. As you pointed out, yes, there is an appeal, there is a remedy that lies before the Supreme Court. We are far away from a final verdict. This is about the maintainability of the suit. It's an initial victory or a breather for the Hindu side, but the real trial on the merits of the case is yet to begin, Griha.
Absolutely. Let me bring in